My name's Kevin Adams. I'm an Oklahoma criminal defense attorney, and what I wanted to talk to you about today was an initial appearance / arraignment. Now, primarily I practice in Tulsa County. In Tulsa County, the arraignments are held at 9 o'clock in the morning in courtroom 173. That's Tulsa County Court. In municipal court, City of Tulsa Municipal Court, sometimes called City Court, the arraignments are held at 8:30 in the morning in either Division 1, Division 2, or Division 3. And each different division has a different judge that's assigned to that courtroom. And the cases are randomly assigned to the judges based upon a predetermined system that starts before the cases are ever filed. So the numbers associated with those case numbers will automatically be assigned to a judge based upon the random number that it's assigned. The initial appearance or the arraignment is an important step of the process, but it's not a complicated step. Basically, at the initial appearance in the arraignment, the judge wants to make sure that you understand what it is that you're being accused of, and the judge wants to make sure that if you need an attorney, that you have an attorney. Now, in municipal court, you can handle the case yourself unless the judge tells you that you probably need to get an attorney, okay? And the reason the judge may tell you probably need to get an attorney is because the case may carry jail time. Now, in county court, you're going to need a lawyer typically. Sometimes people try to represent themselves. It usually does not work out well for them. Abraham Lincoln famously said, "A lawyer that represents himself has a fool for a client." And that's actually some pretty good advice. It's not a wise thing to try to represent yourself in a criminal case. Now, at the initial appearance and arraignment, if you have an attorney, it's going to be very simple. The attorney is going to approach the judge, is going to tell the judge which case they're there about. The client will stand up in the back of the courtroom. Typically does not have to even come up in front of the judge unless it's indicated to you that you should. And the judge will give you another court date so that you can resolve the case. On very minor cases, you may be able to plea at the arraignment and resolve the case, but typically you cannot plea at the arraignment because the prosecutor, whether it's the state or the city, does not have its file and it's not prepared, and nobody's had an opportunity to see what evidence the other side has. So typically you're going to have to schedule a separate date, a second date. Now, if you're charged with a misdemeanor and you hire an attorney, by statute in Oklahoma, the attorney can do the arraignment for you, but you need to make sure that you're on the same page with your lawyer, okay? And that your lawyer is in agreement that you're not going to be there, and your lawyer understands that you're not going to be there, and that you really have the lawyer retained. There should be no confusion about it. Any confusion at all, you need to show up to court and make sure that you're there. Now, on a felony, you have to be there. Sometimes, in certain circumstances, and you can't count on it, a lawyer can get the judge to take a bench warrant under advisement, which simply means the judge is not going to issue a bench warrant for the person. They're going to take it under advisement so they keep jurisdiction, and as long as the defendant shows up or the accused shows up at the next court date, then no bench warrant is ever issued. It's a technical legal thing to make sure that they still have jurisdiction and they don't have to go out and arrest a person again. If the person arrest a person again and it allows them jurisdiction to issue a bench warrant if the person fails to appear at the second appearance, even though they weren't told directly by the judge to show up at the second appearance. It's nothing to be alarmed about if you see bench warrant under advisement on the docket sheet on your case. It's nothing to be alarmed about. That's actually a good thing. It means that your attorney has taken care of business and that you did not have to be there. I hope this helps you understand a little bit about the criminal justice process in Oklahoma. And for more information, you can visit the Oklahoma Criminal Law Guide, which is something that I put out on the internet. If you search for the Oklahoma Criminal Law Guide, you'll find it, and there I answer lots of questions.